correct me, Anubha, if I'm wrong.
Right, thank you.
And Kritika, who's a CCG fellow, works very closely with us, and she's also a privacy rights expert, and also runs her own litigation practice. Survi, of course, is the author of the paper. She's an assistant professor at the Jindal Global Law University, and she teaches family law and jurisprudence. I hope I have not made errors in those introductions. I'll actually now like to hand this over to, so just a quick disclaimer, we'll be recording this session, everyone. The parts where Survi's presentation will happen and the discussion between me, Survi, Kritika, and Anubha. And after that, at 5:30, we'll go into an audience round where we'll let everyone ask their questions and engage with the experts. That on that part, we'll stop the recording. I'll stop speaking now and I'll hand it over to Survi for her presentation of the paper.
Thank you. Can you enable share screen at my end, please?
Yes, I can do that. Are you not able to share now? Now? I've enabled it.
Yeah. Thank you.
Oh.
Okay. Hi, good evening to everybody. Thank you for joining us here in the middle of a work day. And I'm hoping that you might find something useful that you can take away from this presentation. So this paper is an attempt to do primarily two things. One is that we wanted to see the relevance of the landmark Supreme Court judgment in case Puttaswamy versus Union of India, where the Supreme Court has reiterated, clarified, expanded upon the fundamental right to privacy. The relevance we wanted to see it against was how are women accessing abortion in India? And this became a little contemporarily relevant also because in March, the Medical Termination of Pregnancy Amendment Act was published, and it has, like Shashank mentioned, been notified to come into effect from the 24th of this month. And so surrounding these events, we thought it would be a very good idea to see how privacy interacts with women's access to abortion in India, particularly since the law has undergone some changes. And related to this is the second purpose of the paper, which is to examine the actual changes that are brought in by the amendment to the right to access abortion in India. Right to access abortion is one of the subsets of a broader right to abortion in India, which I'll sort of be talking about in detail a little bit later. And we wanted to see that how are the recent changes in law sort of complying with the clarification and the sort of explanation that has been put forth by the Puttaswamy judgment. So because this paper is both a little bit exploratory and explanatory, so some parts of this paper I have tried to organize them in a sense that they read like a repository of case law of sources on access to abortion, and some part of the paper is exploratory in the sense that we look at what were the issues existing in India before Puttaswamy that women were facing when they access abortion, and how have these issues been addressed by the amendment, and if these issues are already affecting an existing right to privacy and have not been cured by the amendment, so as to speak, then how does the amendment test against the Puttaswamy judgment? Okay. Having said that, we'll just quickly go over the amendment and the changes that it has brought. So, like I mentioned, it has come into effect now, which means that any access to abortion in India from 24th September onwards will have to happen under this changed law. Now, interestingly, when this act was in a bill form, there were objects and purpose stated therein. Now, in the notified version, you may not find this, but if you go back and look at the Lok Sabha, Rajya Sabha versions of the bill, you will find that the objects and purpose of the bill that, as per the parliament, were to ensure better access to abortion by ensuring, confidentiality to women, by ensuring that they have justice in some form, by ensuring that equal access is available. And there were also health-related objectives of reducing maternal morbidity and ensuring that a safe space of medically and surgically accessing abortion is available. So, with these objectives in mind, the changes that were brought in finally and how the act was passed is that the first important change that we see here is that where in cases a pregnancy does not exceed 20 weeks, so a pregnancy between, say, from the conception to 20 weeks, you will now require the permission of one registered medical practitioner or one doctor for availing an abortion service. Earlier, the law was from conception to 12 weeks, you had the requirement of taking consent of one doctor, but now this has been exceeded to 20 weeks. So there's kind of a little bit of flexibility. And this is a slight improvement from the earlier position where, if your pregnancy exceeded 12 weeks, but you wanted an abortion, you would have to go to 2 doctors and take both of their consent before an abortion would be performed. Then, the second important change that was brought up by the amendment is that where the length of the pregnancy exceeds 20 weeks, but is less than 24 weeks, only for prescribed categories of women, an abortion is available on the consent of 2 doctors. Now, interestingly, what these prescribed categories are is something that we don't know as of now, because first of all, the act has just come into effect. So the interpretation exercise will only just begin. And the rules under the MTP Act are yet to be notified by the government. So we're hoping that some clarification is forthcoming, but there has been some speculation going around this, and one can maybe safely assume that rape survivors, sexual assault survivors will be able to fit this category of prescribed category, where if in case of a rape survivor, the pregnancy exceeds 24 weeks, then, exceeds 20, but is less than 24, they will be able to access abortion. Now, another important change brought by the amendment is that the failure of contraception, which was a ground for an abortion, earlier was only available to married women, has been extended to non-married women because the word married has been removed. The Act for the first time now provides for composition of medical boards, which are boards which have qualified doctors on them, qualified specialists. And the role of these medical boards now under the new law is to, in cases where there is a substantial fetal abnormality, they will be able to decide whether the women can seek an abortion beyond the outer limit of 24 weeks. So even if the 24-week limit is crossed, but in the opinion of a medical board that there is a substantial fetal abnormality, a woman can still get an abortion. Earlier, in such a case, a woman would have to go to a court, and courts were the ones setting up medical boards on a case-to-case basis. There were no permanent medical boards. Now the Act envisages permanent medical boards. These permanent medical boards have to be set up by states and union territories, and the appointments and qualification of some qualifications are mentioned, such as which specialist must form part of the board, but other requirements have to be fulfilled by the state. Then there is the important confidentiality requirement. Now medical practitioners must maintain confidentiality of a woman upon when abortion has been performed. And this breach of confidentiality is now a criminal offense, which was not existing earlier. Now this brings us to what is a right to an abortion. In my paper, I have tried to discuss this as a very wide umbrella term. And I've taken help of international instruments such as the ICCPR, the CEDAW, which under their respective rights to health have discussed what a right to an abortion can be. And the literature that we see there tells us that a right to an abortion is a broad term under which several things can exist. For example, under granting a wide right to an abortion, the state must not criminalize abortion. The state must ensure that pre and post-abortion care is available, medical abortion is available, that unnecessary hindrances, such as where an abortion can take place and who can perform an abortion, are avoided. And I have done some analysis of these international instruments, and thereafter I have looked at Indian law. And under Indian law, I have examined statutes. So the relevant statutes for us here are the IPC, which criminalizes abortion. There is a specific term under sections 312 and 313 of the IPC, which is causing a miscarriage to a woman is the term used. But essentially in India, because the Medical Termination of Pregnancy Act exists as an exception to the Indian Penal Code. And it's from these two statutes, that is the IPC and the MTP Act, can we glean what are the contours of a right to an abortion. And when we see that how the case law has emerged from these two statutes and what are the various interpretations, we will see that the right to an abortion in India is largely statutory, and it is a limited right, and the limitations are as per what is provided for under the Medical Termination of Pregnancy Act. So there is not an unqualified right to an abortion in India, like you can't just demand for an abortion in India. And this has been true both before and after Puttaswamy. So before Puttaswamy, whatever the case law has been so far as the right to an abortion is concerned, is something that I have discussed in a little bit of detail in the paper. An important and crucial judgment in this regard is the Suchita Srivastava Supreme Court decision of 2009, wherein the Supreme Court has in some detail discussed that there is not an unqualified right to abortion in India, and that there is some compelling state interest in protecting a fetus and in protecting a woman's health. And therefore, the restrictions that are available under the MTP Act, that a consent of a registered medical practitioner is required, that there must be some risk to the mental or physical health of a woman, and the other conditions that are existing under the MTP Act, these have to be satisfied. There isn't an unqualified right. Now, Puttaswamy, of course, discusses a right to an abortion in a privacy context. So you will find some direct observations of Justice Chandrachud specifically and Justice Nariman too, where procreation and its related rights, and abortion is included in that, is recognized as being included in a broader right to privacy. And there are both specific and general observations under Puttaswamy, which I have captured in the paper, which are applicable to a right to an abortion. Now, post Puttaswamy, what is a right to an abortion is something that I've tried to understand through existing case law, but unfortunately not a very clear image appears, because one is that the judgment of Puttaswamy is fairly recent, and also because Puttaswamy has been not used a lot by lower courts while deciding a right to an abortion or while deciding cases under the MTP Act. So there are many reasons for why this jurisprudence is not as developed at this stage, but one hopes that that will happen at a later stage, right? Okay. Now, the next part of this paper that I discussed is why is privacy as a right right, generally, not just limited to Puttaswamy, is relevant to women and accessing abortion, within which I have discussed how privacy facilitates reproductive decision making, which includes abortion, which includes access to contraception, which includes accessing methods such as sterilization, and how privacy therefore affects health, right? Because as a matter of practice, when women in some social setups have very little control over when they become pregnant or whether they can use contraception or not, abortion is sometimes used as a family planning method, unfortunately. And it can, then have effects on health of women. And if, for example, a woman does not want to fall pregnant because it affects her participation, for example, in the labor market, or it will affect her job, her employment status, then a right to an abortion is important, and privacy facilitates this as well. It's something that I've discussed. Now, different aspects of privacy, which in Puttaswamy you will find in Justice Nariman's opinion specifically, decisional, informational, right of control over one's body, are also very relevant to an access to abortion. For example, informational privacy, whether how much information of a woman who is seeking an abortion can be made public or not be made public is relevant, especially in an Indian context, right? For example, where women find it difficult to take abortion-related decisions outside of her family, and sometimes, try to access it without knowledge, without the knowledge of their spouse or their relatives. So informational privacy becomes very relevant there. And I have also discussed how privacy is an enabler of women as moral agents, as taking the moral choice of what to do with their body. Then I have tried to discuss what are the limitations and critiques of privacy as a concept in understanding access to abortion. So I have in this section tried to discuss how privacy, as a concept does not necessarily create a positive obligation upon the state to provide venues for access to abortion. For example, while arguing from privacy, you can't necessarily argue that the state should provide, for example, free access to abortion in all places, or that there should be compulsory free access to abortion. There should be availability of hospitals, there should be practitioners. Well, that is an argument one can make now under the kind of privacy that is imagined under Puttaswamy, but it is a critique of privacy overall that is maintained by feminists, that it is not something that creates a positive obligation upon the state. It is more of a negative right. Then what I've also discussed is the feminist critique of privacy, that privacy tries to maintain the status quo of heteronormative, patriarchal, oppressive structures, such as the family, the marriage, and it doesn't question the very fundamental oppressiveness of these institutions. And in fact, it tries to, most of the time, these institutions, under the garb of privacy, try to hide their oppressive practices. So these are some of the critiques and limitations to privacy that I have discussed in the paper. And I have also tried to show how Puttaswamy addresses some of these. So for example, the positive obligation upon the state bit is addressed to some extent in Puttaswamy, where in a few parts of the judgment, you will find that it is the privacy is phrased in such a manner that it must cast an obligation upon the state to protect the privacy. Now, it remains to be seen, of course, how this language is used later on. But to that extent, Puttaswamy is kind of a step forward, is something that I'm trying to show in the paper. Now, the second part of the paper is kind of an exploratory part, like I spoke earlier, where I have talked of what are the various problems with accessing abortion in India. And I want to mention here that the problems with accessing abortion in India vary and will vary with very specific intersectionalities. So if you have intersectionalities of caste, ability, religion, class, and even the urban-rural divide, access to abortion may become more or less problematic depending on where a specific woman is. And unfortunately, I have not addressed a specific intersectionality in this paper because I think that any specific intersectionality deserves its own paper. And I have tried to generally address what are the problems that women face while accessing abortion in India. And I have tried to show that some of the problems, such as absence of qualified medical practitioners, absence of a qualified place of abortion, medical board and the specialists that should be present on it, are some things that are unaddressed even post the amendment. So for example, requirement of a qualified medical practitioner only. So earlier, even before the amendment, we had the issue of women not being able to find enough doctors who could, legally provide an abortion service. And this was particularly problematic in non-urban areas. And there is still a very acute shortage of public health service providers in this category, which results in women having to turn to private facilities to access abortion. And this is especially problematic for women from vulnerable, socioeconomic vulnerable backgrounds. So this issue, because now this requirement of a medical practitioner is not changed as of now under the amendment. We're yet to see if it is changed under the new rules. But since this position is largely unchanged, there is not an improvement in access to abortion even post the amendment. So like this, I have addressed some of the issues. So there are these locational infrastructural issues. There are issues relating to timeline. For example, if abortion beyond 24 weeks is only on diagnosis of a substantial fetal abnormality, why is this benefit not extended to, for example, rape survivors? For example, in cases where rape survivors sometimes have a mental disability and the pregnancy is diagnosed very, very late, in such a case, an abortion will be not allowed post the amendment. These are some of the issues that are unaddressed even post the amendment. Then there are information and knowledge related challenges. So a large section of the population believes that abortion is illegal or finds inconsistencies between the Prenatal Diagnostics Act and the MTP Act. And then there are also issues relating to whether all abortion is surgical or even medical abortion is available. So these information and knowledge related challenges I've also tried to show remain unaddressed even post the amendment. And therefore, the questions after this analysis that I think are necessarily coming forward are that how are the stated objectives of achieving dignity, autonomy, confidentiality, and justice for women? This quote I've borrowed from the bill itself being met. How is the constitutional right of making reproductive choices, which is encased within a broader right to privacy, being ensured by the amendment? And what could be the Puttaswamy effect on the amendment? Earlier, when I started speaking, is that these issues, and I've tried to explore it. These issues of access to abortion, which remain unaddressed even post Puttaswamy, could potentially pose a challenge to the amendment on grounds that it does not meet the requisite right to privacy as guaranteed by the Puttaswamy judgment. So I've tried to kind of conclude in the paper that there is a right ground for a constitutional challenge to the amendment in this sense. And in the conclusion, therefore, I have tried to show how the law can be harmonized with the Puttaswamy mandate. So, ensuring policy level overhauls such as availability of doctors, abortion sites, ensuring there is some degree of abortion on request, especially in cases of early term pregnancies, doing away with criminalization of abortion, and creating meaningful choices for women, making sure they have facilities that are not expensive, that are not far. Medical abortion is more easily available, are some things that will make the law less vulnerable to a challenge. And generally how lower courts, after the Puttaswamy judgment has come, in cases of MTP, use the Puttaswamy judgment and its jurisprudence to decide cases of MTP. And further, the privacy rights of women is something also that I've tried to discuss in the paper in the prelim portion. I think I'm shooting this a little bit. This is it. This is overall the structure of the paper. Sorry, Shashank.
No, that's fine. And thanks so much, Surabhi, for that good discussion about what the paper covers and what are the limitations as well. So I think I'd like to start the discussion now. So if Kritika and Anubha, both of you can also switch on your cameras. And Kritika, I'd like to start with you, put you on the spot. Surabhi in her paper talks about this fact that even after Puttaswamy, and looking at some of the other jurisprudence from the Supreme Court, where this court has clearly laid down that the state might always have a compelling interest in regulating termination of pregnancy because of the sort of impact on the life of the person who's bearing the child or the fetus. What are your thoughts? Do you think that there is a limitation when we read Suchitra and we read Puttaswamy together, or there is some way that we can interpret Puttaswamy to say that because it talks about bodily autonomy and integrity and privacy and autonomy in general and sort of promotes choice, something else can be argued. And just to add a line there, we also at CCG believe that one of the impacts which Puttaswamy has had, and especially Justice Chandrachud's judgment, has been on gender rights. We've seen that even in Navteej Johar. So passing the mic to you now.
Thanks, Shashank, and thanks, Surabhi, for that very nice and succinct presentation on the paper. I really enjoyed reading it. To be very honest, a lot of my work is on data protection and like the tech side of privacy. So it was very nice to read a paper and going back to first principles of privacy and really what it means for bodily integrity and decisional autonomy. And you're right, this discussion is also very, very timely given the MTP Act amendment has just come into force last week, and we've all been discussing about what the amendment means and what are the gaps in that amendment. And so thanks, Shashank, for that question and for starting off this discussion. And I think, I think we always knew Puttaswamy was not going to be some sort of magic wand, right? Because it was decided in a vacuum, in the sense that there were no facts and no sort of no facts or case on which the court had to apply the right to privacy. And so the court really had a free ground to go all out and declare the right to privacy in the widest terms. I think it's helpful in the sense that articulation of privacy is extremely helpful, and it was something that was missing in our jurisprudence over since the 1950s. And so one of the core sort of facets of privacy that the court articulated was decisional autonomy. And just to break it down, I know Surabhi's done already an excellent job of describing it in the paper, but like the right to make choices that are integral to your life without the state interfering in it. And if there is an interference from the state, then to see whether or not those restrictions are justified or not. And Puttaswamy sets down those three tests, or that three-part test, to see whether or not these restrictions or this interference with privacy is justified or is permissible. And broadly, those tests, I think now everyone is familiar, but for the benefit of those who probably would not have read it, that the interference must be prescribed by law. It must serve a legitimate state aim, and it must be proportionate. So it must be proportionate to the interest. The interference must be proportionate. It shouldn't be a restriction which is just unnecessarily disproportionate to the aim that it's trying to achieve. And so just keeping that sort of structure in mind, when I was looking at the MTP Act, even with the amendment, I think for me, that was the dissonance, right? Or the gap between Puttaswamy and the Act. I think it's purely on first principles, it makes sense for the court or even the state to say that there is a legitimate state aim in abortion or access to abortion. But we have to see what that aim is, right? Is that aim simply regulating, when can the right be exercised, or till when? Who can perform an abortion? Where can an abortion be performed? And so are those restrictions, or termed differently, those safeguards, only such that they allow you to exercise the right more meaningfully or in a safe way? Or are those safeguards or restrictions under the Act actually restrictions? To me, I think it makes sense when you say that the court can, or the state should regulate abortions, as long as that regulation is aimed at furthering the right or allowing you to exercise the right in a safe manner. But when the state starts saying that you can only exercise the right to an abortion if X or Y condition is met, there must be some grave physical injury or medical injury, or there must be a threshold, there must be a risk to the life of the child, which must meet a certain threshold. That, to me, I think, is the gap between Puttaswamy and the state of the law right now, and what the law under which Suchita Srivastava was decided.
Right.
And because it was a decision which was under the Act, and not a challenge really to the provisions of the Act, I think in some senses the court was bound by those conditions which the Act prescribed. I think it was unnecessary for the court to have said that there's a compelling state interest in the life, in protecting the life of an unborn fetus, because in the sense that there was no challenge there from the state that justifying why those conditions exist, right? It was simply a question of whether these are the conditions under the Act, and are they satisfied or not, subject to, again, correction from Surbhi or Anubha on this. And so I think if Suchita Srivastava had to be decided today, I don't know if the conclusion would be very different, because it would still be a case under the MTP Act, the Amendment Act, with those limitations or prescriptions still standing. But if, say, it were a constitutional challenge to some of the section requirements under the Amendment Act, then I think there is definitely a very, very legitimate argument to be made that what is the aim of these restrictions? What is the legitimate state aim? What is the government justification, or the state's justification in not allowing an abortion? Why must a person who's intending to exercise that right have to always meet that threshold or that criteria? And so I think that's the argument that will perhaps have to be run in the future, for us to arrive at a different conclusion compared to Suchita Srivastava.
And what I got from Surbhi's paper is that the state, and I mean the courts have also said that the protection of the life of the person who is bearing the child is an important question which we have to sort of come to. And I want to come back to Kritika. I'll go to Anubha now, but I want to sort of, so from what you're saying, I want to sort of ask you, can we argue for like a non-interference of state, legal sort of reality when it comes to sort of abortion and pregnancy, like it is for sort of, let's say, other medical decisions between a citizen, an individual, and their doctor. I would like to sort of come back to you on that. But coming to you, Anubha, I think as I was saying before as well, it'll be interesting to hear from you how pre-Puttaswamy, post-Puttaswamy as well, what are the sort of practical challenges with the access of abortion that people face in India? What have you seen in your work? And does the amendment make any substantive changes that will really impact people's lives when it comes to access under the law? And any other thoughts, of course, which you have from Sylvie's paper and presentation as well.
Okay, so let me just answer your second question first. So of course, I mean, anyone who's done any work or is doing any work on access to abortion will agree that the MTP Act required amendments. And there was a lot of work that was being done around those amendments for a really long time, I think almost 15 years now. But having said that, what we have finally got in terms of the amendments is not, I don't think is even 50% of what what was agreed upon earlier in the earlier drafts really. So while the amendments are of course they're welcome, but there is a lot that could have been done. Because obviously amending a law is not a simple process. The fact that we have amended the MTP Act only the second time in 50 years, and this year marks the 50th year of the MTP Act, says a lot. So we could have at this stage ensured that we are ironing out all the concerns that are there with the with accessing abortion, accessing MTP services. And including that it is in line with the Supreme Court rulings, not only in Puttaswamy, but even in the others like Navtej Johar, like like the Nalsar judgment, etc. And also in line with the other laws like the Transgender Persons Act, like the Disability Law, like the Mental Health Law. I mean, just sort of taking on what Kritika was saying about if the Suchita Srivastava case was would come now. I think one of the most important aspects would also be looking at the applicability of the Mental Health Act, which came in 2017, which was not there at that in its current form at that point in time. And unfortunately, the MTP Act is not in line with the mental health law. The definition of mental illness, etc., that's not clear. The definition of a child is not clear. The definition of a guardian is not clear. And by not clear, I mean that there is there are various definitions, and there's no ironing out of any of the differences that exist. So while we did the exercise of the amendment, we didn't really complete it, frankly, from where I look at it. And really responding to your first question, I mean, the kind of concerns pre-Puttaswamy, post-Puttaswamy, let me be very clear. I mean, and I said this even when I was looking at Surbhi's paper, and I mean, like I said, it's a fabulous paper, and it's really required to look at privacy and access to abortion specifically, and access to SRHR services generally in the country, and sort of start documenting that in this way. It's really important. But having said that, the fact that the Puttaswamy judgment is not about abortion, while it is about privacy, it is not about abortion. It is not about access to safe and legal abortion services. It's not about the implementation of the MTP Act. So the effective portion of that judgment is about what is about the issue for which this issue was really raised. Everything else that has been said is for the lack of a better term, a byproduct. And so I mean, the 9 judges can most definitely, most respectfully say that in our opinion, in our understanding, in our reading of the Constitution and interpretation of the right to life and the right to privacy, now the decision of whether to continue a pregnancy or terminate a pregnancy is entirely of the pregnant person. But if your law, which got amended after this judgment, does not reflect that, what's the point really? I mean, we will have to go to court again on this at some point in time. I don't know how soon or how late, but because it's not enough. So while it's there and it's fabulous, I mean, we required that kind of language, we required that kind of interpretation, we required that to come from the highest court in this country. But it's not enough to change the ground reality from day one. Even before the judgment, even after the judgment, even before the amendment, even after the amendment, we have doctors who will ask the woman for her husband's permission.
Yeah, I was just about to come to that actually.
They will ask for the husband or the spouse or the partner to be there. And where it's not in a marriage situation, they will in fact insist on the parents to be there. So and what about the violation of privacy and the implementation of POCSO with the mandatory reporting?
Yeah.
So how do you ensure the confidentiality aspect and the privacy aspect for accessing abortion for a person who's below 18? By ensuring, but you're still insisting on the mandatory reporting because that is part of the law. You can't shy from it. Yeah. So I think there is, from this perspective, what we have, frankly, from where I look at it, is the starting point.
Yeah.
There is a lot of work that really needs to be done, not only in terms of, maybe litigation, but definitely in terms of writing, of discussing, of asking these questions, of really holding people accountable to the fact that when your own court is saying something, how can you not have a law which is in compliance with that? Yeah.
In fact, Anubha, you mentioned about this practical reality of women actually not having decisional autonomy, whether Puttaswamy or not, practically. Like to, I know you've already said that even now they ask for the husband's sort of involvement, and but again, what has been our experience in this, that even before the courts, are women facing, are they sort of hesitant to come and seek the recourse of law because there's so much, in patriarchal setups, women often don't have the decision autonomy, which we're talking about. And, there's family, there's of course spouse involved. Get your thoughts on, we're talking about decisional autonomy, but to start with, there is no decision autonomy in the patriarchal setup itself. So.
So a very interesting thing that happened is from the year 2016, we saw a lot of cases coming to the Supreme Court where women were filing writ petitions asking for the court's permission to terminate the pregnancy because it was beyond 20 weeks. Yeah. We saw 21 such cases go to the Supreme Court. And, I can be held in contempt for this, but all 21 times the Supreme Court decided not to settle the law, but decided to only decide the case at hand. And the 21st time the Supreme Court said, what, you're coming to us too often, please go to your high courts. So after that, we have seen, and Surabhi was part of some of this analysis that I had done. We analyzed cases till August of 2020, and we saw that there were close to 500 cases across the high courts in this country, where petitions were filed seeking permission of the court for termination of pregnancy. And I think I can count on my fingers the number of cases where the pregnant person had come alone. Otherwise, it was always, where it was a minor, the case was filed by the guardian, who was most likely either the father or the mother. And where it was a major, then in almost 90% of the cases, the second petitioner was the husband.
Yeah.
So even in cases like this, the point I'm trying to make here is that even in cases like this, unless there is, unless there is support of the immediate family, I don't think those 500 women would have come to court. And 500 looks like a really big number, and it is. I mean, 500 petitions in about 4 years on one single issue. But when I look at the number of abortions that take place in this country, 500 is nothing. So there were 500 women who were able to access abortion by going to court, but then there were only 500 who were able to do that. And I mean, one of the other consequences that happened of that is that it created far more confusion, because some of these cases, 24% rather, of these cases were below 20 weeks. There have been cases of even 8 weeks and 12 weeks where people have gone to court and the High Court has, adjudicated upon that matter, has not even asked, why have you come to court? Why should I give you permission for something that's already legal? So you can imagine the confusion that has created.
Yeah.
So, the agreement at the ground level now is that if you need a termination of pregnancy, you need a court order. So, I mean, in that, where are we? And frankly, let's even look at how the law is. How is the MTP Act worded? Is there any decisional autonomy there? No. I can't ask for an abortion. It is only based on the medical opinion of the registered medical practitioner, 1 or 2 or 10 or a medical board or whatever. I can't ask for it.
Yeah. And
I have to fit in those parameters. Otherwise, I'm sorry, I can be very well refused. And that's something that I can't even challenge.
And that makes me think that people who have people who are from privileged backgrounds, are from majority backgrounds, it's obviously easier for them to access abortion, even despite the requirements, because of their caste, their class, and those kind of privileges, which makes me think even more deep about this issue. In fact, I was just talking to Kritika before this conversation about, I also want to pose questions and spark some discussion about, okay, we have the law, right? But all of us, I mean, at least we're lawyers and we know what happens practically is disjointed from the law. And I also want to talk about some of the practical challenges, Anubha, and that's where, thanks so much for being so candid and coming with your experiences. But Surbhi and possibly later to the rest of the panel as well, I want to ask the intersectionality question, right? I was having a conversation with Surbhi also on this before, especially after Nalsa, especially after Navtej. And there is an enabling environment, at least in law, and correct me if you all feel otherwise. But how does access to abortion different for let's say the transgender community, for people with disabilities, for people with not belonging to the privileged caste system, the majority caste system, from different religions? Surbhi, I'd like to pass on the mic to you, and then possibly Kritika, Anubha, if you want to come in that as well. And Anubha, again, I really want to hear your practical experiences with this. Surbhi.
Hi, so I've been recently doing some research on gender and disability, and the kind of work that I'm looking at is a lot of ethnographic studies in India, especially from rural parts of India. And there's a particular work that is from rural Haryana where the author, she looks at how women make decisions. Women with disabilities make decisions about their bodies, about who to marry, how many children to have, and how these decisions at the same time are not always of the woman, because sometimes there is a patronizing attitude around not only the gender of the person but also the ability of the person. So disability and gender kind of coincide to make a person more vulnerable, right? But at the same time, there is support and a kind of a protective environment around these decision making. So if a person with a disability she choose to have a child, she will find a closely knit community in which to raise the child. It won't be like she's in a nuclear family or she's in an urban setup where she won't find childcare easily available. So there are kind of these enmeshed realities of women, which women negotiate and which women have to make their way through. So you have to, pick and choose your battles in most cases. Then another contrast to this is this study that I've been looking at in Delhi on urban women and their experience with disability. And I was particularly interested in the account of this person who was used to teach at a renowned university. She's no more, but her health was so frail that she required 24/7 healthcare support. And in such a situation, for her to have physical intimate relationships and therefore have children was a complete impossibility. But it is something that she really, really wanted. And she said that my parents discouraged me. They said that don't do it. We won't be able to support you and any child that you might have at the same time. So, it's such a complex setup that women constantly find themselves in, and then they have to negotiate on a case-to-case basis. So, depending on where they are, how they are, it just gets more complex, and there are no easy answers, unfortunately.
Yeah. Kritika, your thoughts on this? Especially after NALSA, are there any thoughts you have on the intersectionality question? Should the law by itself now cover the transgender community without sort of legally speaking? Any thoughts which you may have on this?
Shashank, to be honest, I think Surti and Anubha are much better placed to answer the question, since I don't really work in this field.
Yeah.
But so your very last thought of question, of course, the law must be inclusive.
Yeah.
And I can't think of one justifiable reason to exclude people from conferring this right and to exercise the right in an accessible way, right?
Yeah. In fact, before going to Anubha, I want to come back to my earlier thoughts, which I want to ask you is about, does Puttaswamy, or again, Puttaswamy plus do these judgments create a reality where the state must not or cannot interfere in a decision like abortion, and there is no justifiable reason for a compelling state interest, as you were alluding to, I guess, even before previous intervention, and can we sort of talk about a non-qualified right to abortion?
I think we must definitely talk about a non-qualified right to abortion. I think the idea must be to make the right accessible, and for individuals to be able to exercise the right in a safe manner, right? And I understand your question about, we've all seen how Puttaswamy and then Navtej and Sabrimala have dealt with balancing constitutional rights or other apparently legitimate state interests with fundamental rights. But as Anubha has pointed out, and that's been our experience also as litigators and lawyers, that it rarely ever trickles down, unfortunately, and it just there is definitely a sort of policy paralysis or a crisis where we've rarely seen the state take sort of proactive measures and sort of draft a progressive legislation based on what the Supreme Court has said in a judgment, and to sort of incorporating the spirit of a judgment. That's just never been my experience. And usually till there is a mandamus or so to say a direction from the court saying you must do this or you can't do this or this is constitutionally impermissible or unconstitutional, there is rarely a change in the field. To take the IT Act 66A, for example, this is a case where the Supreme Court struck down that section saying it's too vague and it's being misused by the state to arrest people just for satire or just any kind of sort of posts on the internet. And you're still seeing FIRs being registered under something that's not on the statute book. So things are that bad. It's just unfortunate we haven't seen, I mean, this was a great opportunity, right, for our legislators to have incorporated or imbibed the spirit of Puttaswamy, or what Puttaswamy was saying about decisional autonomy. But unfortunately, as Anubha and Surbhi in a paper, and Anubha in her sort of opening remarks right now said, it hasn't happened. And it's we've rarely seen that, or I've actually never seen that in my whatever short 8 to 10 years.
You know what comes to my head immediately from all this conversation, Anubha, I'd like to pose that question to you in addition to your thoughts on intersectionality. Is that what can be done, right? As a policy enthusiast, as someone who thinks about these questions. Okay, fine. We know that the Supreme Court can't decide on every social justice issue. You know, let's lay down broad principles. And that's at that level. Probably the central legislature also, you know, you lay down the laws. But do we need a change in the way rules are drafted? Do we need a change in how the medical fraternity deals with this? Do we need a change? Do we need like more positive policy intervention, evidence-based policy intervention, though that's just become a, you know, like a word now in itself? Just asking that question to Anubha and then all of you before we sort of move on to the more open discussion with the audience. Anubha, passing the mic to you.
You know, I think the law can't really sort of, or the MTP Act, at least in its current form, can't really sort of look at it as a right, you know, because, I mean, let's be clear that the MTP Act is an exception to the IPC, you know, and so till the time the offense in the IPC exists, anything that you do which is outside the parameter of the MTP Act will be an offense under the IPC. I mean, offhand, I definitely don't know whether there have been prosecutions under the IPC because it's a violation of the MTP Act. But I do know that that MTP Act violation is used in a lot of prosecutions of the PCP-NDT Act, which frankly, I do not know why, because the PCP-NDT Act is a completely different thing. And the MTP Act is a completely different, you know, legislation. So having said that, I think we really need to also really question the need for the MTP Act. If we are able to do away with the criminalization aspect.
Interesting.
You know, because the way the IPC sections are worded, even where a woman is consenting to causing herself to miscarry is an offender. You know, so the service provider who's causing her to miscarry is an offender. And if she has given her consent, then she is an offender, unless it's immediately necessary to save her life, you know, so that's the only exception. So the MTP Act is, of course, a little more broader in giving those exceptions. And I mean, I think it also really depends on how did the law really come into being. It's not a law that was fought for by the women. It was not as a result of the women's movement. It was as a result of the fact that the doctors were consistently facing, you know, women turning up at their clinics with incomplete abortions. And so there was, you know, there was a lot of sort of hue and cry that had happened at that point in time in the 60s, late 60s, that we really need to look at this legislation. And, you know, then there is the history of the Shantilal Shah Committee, etc. So it wasn't as a result of the women's movement. So therefore, it is not keeping the woman at the center of it. Thankfully, it's not keeping the fetus at the center of it either. It's keeping the doctor at the center of it. You know, chalo, at least, you know, but let's be clear. So can we expect it to be a rights-based legislation? I don't think so. And I mean, of course, we could have expected it to be now, but well, that has happened. How much can you do in the rules? You know, I mean, we have in our own processes, civil society has given their recommendations of what the rules should look like, you know, to somehow correct the, you know, or bridge the gaps in existing law. But how far can you go with the rules, really? If it's not in the act, how far can you go in the rules? So there is, I mean, the daira to already ban gaya hai na? It's already there. You know, so there's, so we definitely really need to look at the need for the MTP Act. We don't have a law on heart surgeries. We don't have a law on childbirth. So why do we need a law on abortion?
That's true.
You know?
I mean, exactly what my thought is, that shouldn't it be a decision between the person and their doctor? Like,
Absolutely.
yeah.
Absolutely.
Yeah.
You know, so it should be a right that is acknowledged by law, and it should be advised by my medical service provider.
Exactly.
You know, and that's where it will actually show privacy, really. You know, and you know, coming back to your earlier question of intersectionality, I mean,
yeah.
Again, the law is very specifically using the term pregnant woman.
Yeah.
It's not using the term pregnant person, the MTP Act.
Can we say that trans woman will be covered there? I'm being optimistic.
You know, and I really don't know. And you know, I mean, how is that going to play out? I don't even know. And whether a trans person who is also pregnant would be like to identify as a trans woman or as a woman, also I don't know.
Yeah, exactly. Yeah.
You know, so can we have a term which is inclusive?
Yeah.
Instead of expecting someone who may not identify as a particular person to be identified as that. You know, so I think, I mean, and again, I mean, there we are. Well, at least there's some part of the battle is you know, is done if we have the right terminology. But frankly, what will really happen at the ground level, one can't really say. How far have trans persons been able to access any MTP services which are safe and legal? One can't say. How far have sex workers been able to access? One can't say. You know, because there is a lot of other factors that really come into play. If it's a Muslim woman, if it's a Dalit person, and with disability come a whole other set of concerns about you know, whether you can decide whether you should be pregnant or not, whether, you know, isn't it better to just you know, ensure that you're not taken advantage of, and therefore you know, forced sterilizations, forced operations, etc. So there is, I mean, there's a whole gamut of things that we are dealing with, and unfortunately our law is still in 1971. You know, so it's, I mean, what do you do with what has been given to you, the hand that you have, that has been laid for you? How far can you go with that? I think we really need to sort of shift gears and see, can we imagine beyond the legal parameters that the law is setting out for us? Are there other things that can be done?
Yeah, thanks so much for that intervention, Anubha. And it seems to me that, you know, the conversation around in the US is you know, coming from a lot of you know, religious sort of undertones, and like everything else, unfortunately, in India seems to be that patriarchy is ruling women's bodies still. I'd like to open up the discussion now and let people join in. I'd actually like to go to I think we have Mihira Sood with us. I'd like to go to them. I'm just going to allow them to. Yeah. Mihira,
audible?
Yes. We can hear you. Please go ahead.
First of all, I just want to say congratulations, Subhi, for a really, really excellent, well-researched paper. It was really very illuminating. Having worked in the field of women's rights and child rights as well, there's just one aspect that I would like to bring in here that I think has been the reason, you know, because I've done some policy work on this issue as well, that I think has been the reason for providing this kind of regime where the right to seek abortion is not left entirely
Hello.
That is the issue of female feticide.
Sorry, Mihira, we lost you for a second. Sorry.
I said I'd just like to bring in one issue that is, I think, has been weighing on the minds of the legislators when it comes to, the liberalization to the point of, making it solely on request. And that is the issue of female feticide. Right, that has been, and a lot of the work that I've done with women has been, more in fact of being forced to get abortions against their will, because they have been, found through illegal ultrasounds, etc., to be carrying a female child, and therefore, you'll see the language of the act that that says that, even a failure of any device or method used for contraception can be presumed to be causing sufficient mental anguish. That, I think, was the legislators' sort of middle path, so to speak, to provide a fairly liberal regime, but to ensure some kind of oversight, to ensure that it is not being done solely on grounds of sex selection. Right, and that's something I think when we talk about abortion rights, and because both issues connect very deeply to the issue of equality for women and girl children. So that also needs to be kept in mind, because as Surpi's paper very correctly pointed out, rooting these decisions in privacy, autonomy, etc., very often does not reflect the lived realities of women. This problem gets exacerbated when women are forced to get abortions, and that's made worse by the fact that it is for reasons of sex selection. So maybe that could, if that sheds any light, or could lead to a further discussion, or maybe even a further paper on then what then is the solution beyond really real grassroots solutions as to what is it that is disincentivizing society from wanting to have girl children, and specifically targeting those particular problems, whether it is dowry, inheritance, etc.
Yeah, Anubha, would you like to comment on that? Any thoughts and anything you'd like to share?
I think it's really, thanks Mihira for bringing that up. I think it's really important to understand that both the laws have their own very, very different scopes. And the offender under the PCP&DT Act is the specialist. And under the MTP Act, it's a completely different offense if there is an offense. And frankly, if I know the sex of the fetus and I still fall within the parameters of the MTP Act, I haven't violated the MTP Act. There is a violation of the PCP&DT Act, and that's that. There is a reason why the PCP&DT Act also stops at making the communication of the sex of the fetus or the selection of the sex of the fetus an offense. Even with that information, if I continue the pregnancy, the offense under the PCP&DT Act still remains. And I think I don't really completely agree with Mihira here. I don't think it's correct that that abortion on request was refused because of the fear that it will increase sex selective abortions or gender-based terminations. In fact, to ensure that there is a balance as far as that is concerned, the idea was to ask for abortion on request only for the first trimester to begin with, at 12 weeks, where at least up till now, at least the known technologies will not be able to tell you the sex of the fetus that you're carrying. And in any case, there is already a backlash that we see, because the understanding that the Drug Controller's Office has is that the MA pills, the medical abortion pills, are used for sex selective abortions. And so therefore, even though the MA pills are approved only up till 7 or 9 weeks under the MTP Act and under the DNC Act, they are just not available, because the understanding is that, they are being misused for sex selective abortions, which is, let's be clear about how this really plays out for people trying to access safe and legal abortion services. And I think it is really our responsibility to ensure that the messaging down there is very clear that these are two separate laws. And I completely agree as far as this aspect is concerned, that there is a lot more that is required to be done. Obviously, by a strict implementation or stricter implementation of the PCP and DT Act, we are not going to solve the issue of the mindset of the people, or how patriarchy creeps in, etc. So obviously, just the law is not sufficient. But let's not pit one law against the other. Let's not pit the female fetus against the woman, a live, breathing woman right here, because that's not what the laws are. And I think that is really important to understand.
Thanks so much, Anubha, for that, and thanks, Mihira, for your intervention as well. Would you like to respond, Mihira?
Can I say something?
Yes, please go ahead.
So just to clarify a couple of things. I mean, of course, I'm broadly in agreement with everything that Anubha said. But I do know that the sort of the extension to 20 weeks did sort of prompt this consideration, because by then, the gender of the fetus does become clear. And that sort of did prompt this consideration, and I do know that for a fact. Secondly, I think, as I said, I mean, don't misunderstand what I'm saying. What I'm not saying that the restrictions that have been placed here are a good idea, but it is, I think, the government's usual sort of ham-fisted attempt at ensuring that there is some oversight, rather than, I think the idea of it being completely on request was something that I think the prospect they were not willing to deal with for various implications, this being one of them.
Yeah, I think that's what I keep coming back to this, that probably some data might help here, and happy to be corrected. Are women actually, or are people actually coming in to get abortions because of that issue of female feticide? And what are the various reasons they come in for? I'm not sure if there is data in here. I was actually listening to a very interesting science podcast from the US, where there was some very interesting data as to what is the major reason people are coming in for abortion. And one of the biggest reasons were financial incapability, and of course, domestic abuse and violence. I'd like to open the discussion up even further. Nandini, would you like to jump in? I've given you the permission to speak. Prasanna, you had a comment on the Q&A module I saw. Please feel free to jump in as well. Ujjwala as well. Please feel free to jump in. We can have like a last 10-15 minutes of like an open discussion.
Should I go?
Yes, Prasanna, please go
ahead. Yeah. Many congratulations on most fascinating paper, Subi and team. One of the highlights in Puttaswamy, other than the declaration of the right to privacy itself, and the prescription of tests, of course, is that it nearly unanimously and unequivocally re-embraced the theory of inherent rights. Right? It is one thing if the courts don't engage with the so-called pro-life arguments, but they still do. Right? That is why we see that even in several judgments, as you pointed out, it's still posited as the right of the fetus versus the rights of the woman, right? So do you think actually the idea of inherent rights will create more obstacles in the effective realization of abortion rights? Perhaps getting tangled up in questions such as when do rights begin inherent?
Interesting question, Surbi, Kritika, Anubha. Would someone like to jump in? I think Prasanna is saying that the recognition of inherent rights, does it start with the fetus itself, and will that be a challenge to the right to abortion? And Anubha, actually everyone, have we seen such cases where the right of the fetus has been argued before court? and what has been the sort of the conclusion to that? Yeah, anyone? Surbhi?
Anubha, would you like to take this? I mean, I'll just start. Maybe you can correct me if I'm wrong. So there are odd cases here and there where high courts in India, especially, have discussed that what is the right of a fetus, and whether in a particular case the right of a fetus must prevail over the right of the mother. Fortunately, this kind of analysis has not found much traction across the board. And although you will find these odd cases here and there, it's not a very uniform kind of a reasoning that you see, at least in the majority of the cases. So that is, and it has to do with the origins of the abortion law in India as compared to, say, another jurisdiction like the US, which maybe looks at it from like a very Christian religious perspective, and that has not happened in India as such. So that is one way to look at it. And so far as arguing from an inherent right perspective goes, I think if one were to see it as becoming problematic, one would have to necessarily argue that there is an inherent right of the fetus posited against the pregnant woman. And relying on Puttaswamy, I don't see a possibility of that, at least using the language of Puttaswamy, because like I already said, there are odd cases here and there where you will find judges making these off remarks here and there, but it hasn't found much traction. So unless like a very a strong indication of this directly appears from the Supreme Court, I find it unlikely that inherent rights of a fetus pitched as against that of a pregnant woman in an abortion context is something that we will see very soon. Anubha, what do you think?
Yeah.
So, I mean, I think we all know this, that as far as rights are concerned, except for in property matters, and we've seen a couple of cases of motor accident claims compensation, where the fact that there was, that someone was pregnant and there was a fetus is considered. Apart from that, I don't think there is there's any sort of major judgment or jurisprudence which is really saying that one needs to consider, or that a fetus also has rights or has fundamental rights or has human rights, etc. But having said that, and the MTP Act, like I said, it doesn't keep the woman at the center of it, but it also doesn't keep the fetus at the center of it, which is, thank God for that. But when we look at some of the judgments that came, especially from the Supreme Court, the fact that the fetus was non-compatible with life, while deciding a case of whether permission for termination of pregnancy should be given or not, was something that was also considered paramount. And in some cases, permission was refused, even though the woman was specifically and clearly saying that the continuation of the pregnancy is causing her mental anguish. The permission was refused because the fetus was compatible with life. In medical opinion, given by the medical board concerned, the opinion was that the chances of the fetus surviving after birth are X% or Y%, whatever that percentage was. And that was considered by the court to refuse permission. And there was a case in the Bombay High Court where the woman had sought permission for termination because the pregnancy, she was facing domestic violence, and she had been confined in her house, so she could not access MTP services before 20 weeks. And when she did manage to sort of run away to her mother's house, and she was beyond 20 weeks. So the High Court had refused permission, saying that you have not made out a case of how you fall within the parameters of the MTP Act. When this was challenged before the Supreme Court in an SLP, while the judgment will only say SLP dismissed, the judge hearing the matter had told the lawyer specifically that you are appearing for the woman, you should be appearing for the child. So we're not very far away from this. Let me just say, there have been some petitions filed by some organization, I don't remember their name, something for life or something, where they are constantly bringing the issue, so to speak, of the rights of the fetus, of how life begins at the conception, etc. So it's there. I'm not going to completely discount it now by saying that, oh no, the law doesn't say it. Well, the law still doesn't say it, but the number of times we have gone to court on this now, we have all kinds of judgments for all these aspects. Yeah.
Interesting. Nandini, I saw your comment. Would you like to jump in? Would you like to speak? It would be good to hear from you as well.
Hi, sorry, I was just trying to figure out the mute button. Yeah, so Nandini here. And I think the discussions today are very rich and something that at ACP we constantly deliberate and discuss with as well. And one of the things I should also, sort of point out from maybe a more rights-based approach, and something to keep in mind while we think about these policies, laws, and the rules, that even the approach for, the curbing these, like one PCP, conflating PCP and DT with MTP, misinterpreting the sex determination as sex selection. These are all very slippery slopes, and what they miss is that we have a different context, not the church backed sort of obsession with the life of the fetus as we see in the US, but here we do have a son obsessed culture, and of course there is a resistance towards maybe having more girl children or whatever. But I think the way we are approaching it is very instrumental, that you must have n% of girls to have for the n% of boys that are born, which means that you are again putting those girls in the same patriarchal framework that you are constantly also arguing and debating and trying to challenge and change. So you mean to say that you have to have these many girls for these many boys, so they are all going to be heteronormative, cis bodied, and they will all agree to get married to those boys. So that is another conversation, I think, as activists and people working on human rights issues, we must keep in mind, because it's very problematic, how we look at India and China and the population policies, and call these boys the bare branches. So again, the entire purpose of this, the correcting the sex ratio is also to continue that same patriarchal framework of society, which is very heteronormative, and you have 50% of girls to get married to those 50% of boys. So it's I think a very tricky conversation for us to have, and lot to unpack there. But yeah, the constant conflation of PCP and DT with MTP is a very worrisome, sort of discussion. So that's something I wanted to flag.
Thanks so much, Nandini. And it's becoming extremely clear the value of arguing privacy for this conversation. But it's very interesting to me that it's sparking conversation. That's what the idea we also have in mind. I'd like people to raise their hands, people who are still there. Thanks so much for sticking around. If anyone wants to directly ask a question to the experts here, please raise your hand and I'll permit you to talk. At the same time, there is a question which we have in the module which says, with respect to bodily autonomy of women and allied areas, do you believe there is a lacuna in understanding right to contraceptives in India in the current scenario? If yes, then what kind of measures are we looking at? Does anyone from the panel like to take this question? You can also read it in the Q&A module.
Yeah, I think I completely agree here that there is a complete lack of understanding of access to contraceptives. I mean, and I would say this from both points of view. So there's one place where we don't have any access, and or we only have as contraceptive methods, we only have either the condom or we have sterilization operations. Like there's nothing else in between. And on the other hand, we have a lot of, sort of basket of choice, as it's called. But one is not very sure of all the information that needs to be available, whether it's all there or not. In terms of side effects, in terms of what does it really mean? Can I use this? The patch, the pill, this, that, and the other. So I think, I think we really need to draw a balance somewhere so that there are more choices available. But along with that, there is also complete information, understandable information in the local language available, so that someone can actually then make a decision for itself and is not really dependent on what the public health system or the private health system is pushing.
Thanks, Anubha, for that. Gunjan, I see your raised hand. Would you like to jump in?
Yes, thanks. Thanks so much, Shashank, for leaving some time for me to speak. I just wanted to pull together some of the excellent points that have been brought up in what has been an extremely engaging discussion, and allay some concerns. It's funny how the mind works, brought back some very old research that I had done. To answer Prasanna's question on, whether we're prone to taking a religious approach of life begins at conception and so on and so forth. I don't think there is much room in jurisprudence for that, because the logic under the MTP for the 20 to 24 weeks threshold is whether or not the fetus would be viable outside of the mother's womb. It's a process that they refer to as quickening, I think, technically. Please do correct me if I might be misremembering. So on that, I don't think the right to abortion, qualified as it may be, is going anywhere, because the state does have an interest in population control. And we can view the legislative history of the MTP in that context in the early 70s as well. Excuse me. I'll just stop for a breath. Sorry. So legislative history in the context of population control in the 70s, and it didn't take us long as a society to manifest our very obvious bias in favor of boys, that, just a bit more than 20 years later, the sex ratio dipped to a point where the PNDT Act had to be enacted to prevent such misuse of this qualified right. So just having touched upon all these points, I want to put a question to the panel, since decisional autonomy has been at the center of a lot of discussions today. I wonder if the interpretation of privacy in Puttaswamy creates the room for such decisional autonomy for women specifically. I'm curious to hear your interpretation on the extent to which Puttaswamy helps the feminist interpretation of decisional autonomy.
Okay, thank you for the question, Gunjan. I think simply put, the answer to your question is yes, it does. So it does it both in a very specific feminist sense, in my opinion, where if you look at the tackling of issues of procreation as an umbrella term for a larger right of reproductive choices, then abortion falling within it, that being connected to autonomy and dignity in, for example, Justice Chandrachud's opinion in the judgment, you will find that decisional autonomy finds, from a feminist perspective, finds place in the judgment. And even from a general perspective, if one looks at Justice Nariman's opinion, decisional autonomy and specifically decisions about one's own body feature a lot in his opinion. And I think that is also something that is very relevant to understanding decisional autonomy as such. So in both specific and general sense, one finds jurisprudence on decisional autonomy in the Puttaswamy judgment.
So then the disconnect is between the law and society, not between Puttaswamy and the MTP.
Yes, or the disconnect between MTP and Puttaswamy. But in as much as that the MTP Act has not fallen in the light of Puttaswamy, which is something that Anubha also mentioned.
Great, thank you so much, and congratulations on a wonderful paper, Suji. Thanks a lot.
Thanks, Gunjan. Thanks for the answer. Final opportunities for interventions. Natasha, would you want to join in the conversation? Would you like to introduce yourself and join in? Ujjwala, if you still want to join in, please go ahead. Natasha, would you like to join in? I'm just seeing, are you able to unmute yourself?
Hi, Shashank. Thanks. I have nothing at this point. Thank you, though.
Okay. Thank you. Ujjwala, would you like to join in? Okay. Thanks, everyone. I know we've overshot a few minutes by a few minutes. I think it was a great conversation, and I hope that everyone took a lot out of it. Thanks to Kritika, Anubha, Survi for joining in. We've shared a pre-release copy with, I think, all registered participants of the paper. And by tomorrow, the paper will also be live on our Privacy Law Library website. Please feel free to explore that database. It has a lot of material already on it. And fingers crossed, soon we'll be able to put in even more content for everyone to read through. Thanks everyone for joining in, and that's a bye from us. Jhalak, would you like to say anything?
Just one last thing, that watch the Privacy Law Library and CCG. We're doing a series of papers around the impact of Puttaswamy on various domains of law, abortion rights being our first paper. We have papers coming out around the impact of the Puttaswamy judgment on LGBTQ right to equal marriage, around things like digital payments, to criminal search and seizure. So a whole host of papers that we will be doing across the impact of Puttaswamy on various domains of law. So encourage you to stay tuned and look forward to interacting with all of you again. Thanks so much for being such an engaged and patient audience. It's been a great discussion. Thanks Surabhi, thanks Anubha, thanks Kritika so much for